first question here is, why is there actually a problem with human rights law in the first place? Okay, so we're not looking here, I'm not asking you here about how does the interaction work between human rights law and IHL, about legal principles between them, but just think about human rights law for a minute. What's the problem with simply saying, you know what, yeah, fine, it's an armed conflict, but we can use human rights law to sort out everything that's happening during this conflict? What are the challenges and difficulties to using human rights law, putting IHL aside? Open floor. Can't be the first time you've thought of this. Please.
I am actually one of those scholars who believe that international human rights law should extend. But I think part of the problems is that there are specific protections provided under IHL that may not be provided under international human rights law, and I think that's the problem.
So that there are some protections maybe missing that we need IHL for.
That's correct.
The primary purpose of IHL is to try to balance those things between trying to minimize the suffering and the killing that happens in war, but at the same time recognizing that war is a reality and therefore permitting under the law to target and to kill and to take life, which is something at its core essence that human rights law does not do.
Okay, so there's a question here of substantive compatibility with the needs of the state. What about, and this came up already, what about the geographical scope of human rights law? Is there a concern there or not? If we're saying, let's use human rights law during armed conflict. Does anyone think that there's a problem with that? Anyone on that specific issue? Sure.
Okay. I think the major concern there, especially for extraterritorial application, is practicability. Whether the state would even have the ability to ensure human rights, in territories that either they're effectively in control of or where they have some kind of influence. I think that's a primary concern.
Anything else on the territorial side of things? Sure.
If we speak of international armed conflict, how much responsibility or responsibilities would a state carry on the territory of another state in terms of ensuring human rights? Would it acquire also obligations of the state on whose territory it's carrying on fighting, or will it bear on their own responsibilities? How big is the scope of correlation of responsibilities of both states, of their international responsibilities? So different agents of states would attribute different amount of rights they can ensure.
Thank you. So why don't I come back now to Alex to summarize some of these issues before we move on to additional questions.
Sure, yes. Some very salient issues have already been touched upon. I heard the comment saying that IHL provides sometimes for specific protections that would not exist, or at least not in this manner under human rights law. For instance, yes, take the case, out of my own files, particularly, who is, for instance, entitled to be specifically protected as medical personnel, under IHL. That would be a specific protection that exists under IHL, where you would not necessarily find the same sort of functional protection under human rights. The same goes, for instance, for take the example of international armed conflicts, where there are obviously certain categories of persons particularly recognized. You have the fundamental distinction between who is a combatant, who is a civilian. So these kinds of questions are definitely, on the face of it, alien to a human rights framework. In terms of right to life, here I would defer to our subsequent discussion, because we're going to really delve into a bit more into the interplay between notably conduct of hostilities versus law enforcement. Indeed, these are, on the face of it, fundamentally different paradigms, especially, you know, when you go into an operation, with which mindset you go into that operation. Finally, the point on extraterritorial applicability has been raised. This, of course, is an issue that has occupied human rights courts and tribunals over the last couple of years, with respect notably to military operations, both non-international armed conflicts but also international armed conflicts. And this, the precise boundaries really of that, the extent of extraterritorial applicability is really still a work in progress. What one can say quite bluntly, without going too much into details, indeed, where there is effective control over a certain territory, such as in situations of occupation, there will be a recognition, usually of human rights being applicable, and also as a second sort of limb, if you have control over persons, such as typically in situations of detention. But sort of the interplay even between those two has been quite controversial and subject to evolving jurisprudence within the context of the European Court of Human Rights and others. There was one point I was particularly missing now in the debate, but that is nonetheless vital. What happens, yes, in terms of states, there might be an issue there between IHL and human rights, clearly. But what about, especially in non-international armed conflicts, with regard to the other side, notably non-state armed groups? And the question whether non-state armed groups could have any human rights obligations. This is an issue that is also very controversial. There is a tendency to recognize de facto responsibilities of certain non-state armed groups, but those circumstances might be limited. There is a tendency to recognize where they have stable control over territory and also possess some semblance of institutions that would make them de facto resemble a government. And this speaks also to the issue of being capable of potentially being able to take on the responsibilities that would arise under human rights, which are sometimes elaborate responsibilities. So we're not only talking about, of course, negative obligations of respect, but also especially the positive obligations. For instance, to provide judicial processes, etc. So that requires a lot of machinery to be able to respond to those demands. So that's a specific problem I also wanted to point the attention towards.
Add anything on this? No? Okay. Just before we move to the next question, just then I just want to highlight one of the issues and just to leave you with a bit more food for thought on the extraterritorial applicability side of things, in that the challenge, of course, is how do we even reach the situation where we say human rights applies extraterritorially? Are the individuals, the victims, within the jurisdiction of the state? There are notions of bringing someone within the jurisdiction by the actions that you've taken. And as Alexander pointed out, occupying territory seems to be fairly clear because you have responsibility over the whole area. And the other sometimes is when we talk about control over persons, and often the example that's used is detention. And again, here you have more and more agreements. Detention, fine, we can use human rights law. You're running a detention facility outside your territory. Why shouldn't you have human rights obligations? But just to kind of leave you with a thought here, the challenge is how far do we stretch this? Okay, so the logic easily applies with occupied territory. I think the logic for using human rights law in a detention facility, again, remember that these things can all happen outside of an armed conflict. We haven't got to the interplay between human rights and IHL. You can have situations where states operate, including detaining individuals in another state, not in the context of an armed conflict. Okay? So we're just talking about the question of human rights applying extraterritorially. Now, what if that is not a big, huge detention facility, but people being held, detained in secret? You know, there are cases that came before the Human Rights Committee in the context of South America and trade union issues, all right? So someone abducted and held in a secret apartment, and this is all done extraterritorially. So here, shouldn't we also be saying, if you've got someone, you've detained them, should a human rights law apply? And why shouldn't it, just because you're doing it across the border? So you accept that. Then what if it's not holding someone for a long time in a detention facility, but state agents are holding someone for 1 hour? But state agents have crossed the border into somewhere else, and they're holding on to someone physically, and the person's in their power. Should human rights law not apply? What's the difference between the earlier example? Now they're not holding the person for an hour, but they just grab the person for 1 second, but they put a bullet through that person's head. Okay. Did the right to life not apply? They had that person. They put a bullet through their head, and then let's say, oh, now they fired the bullet, but they fired the bullet from 5 meters away. Should it make a difference that they held the person and put the bullet to their head, or that isn't it still not a case of right to life? And then you sniper rifle 500 meters away, and then drone strike from on top. So you see where I'm going with this. So this is the challenge with extraterritorial applicability. I think logic would dictate going all the way. Because I don't see where you would stop, but this is where the debate occurs. That some people think, oh, you end up going too far, and this is where we have this debate. So that's just a little extra point there on extraterritorial applicability.